Good evening, all. Am I audible?
Yes, sir.
Yes. Thank you.
Yes, sir.
Good evening to all of you. To recap what we have done yesterday, I revised the appeals against original decrees, that is Order 41, read with Section 96, and also discussed about Order 43, read with Section 104, that is appeals filed against orders. Going further, we go to Order 44, which discusses about appeals by indigent persons. Suppose, let us say, a suit is filed in forma pauperis under the provisions of Order 32-33 of the Civil Procedure Code, and the pauperism has been disallowed by the lower court. Then in that case, as far as Order 44 is concerned, the aggrieved party is the person who has not been given leave to sue as a pauper. Then in that case, the pauper whose application has been rejected by the lower court can file an appeal under Order 44 CPC. Please bear one thing in mind, that the appeals by an indigent person can be filed only by him and not by the opposite side. Then under Order 44, it is said, like a suit, what happens is a petition is filed to file the appeal as a pauper. And then what happens is notice is given to the other side, and more preferably to the government pleader who is interested in collecting the court fee. Then pauper inquiry is conducted by the appellate court as far as the appeal is concerned. If the court is satisfied that the person who is the appellant wants to sue as a pauper, he has no means at all, or he has got means but not sufficient means to meet the obligation towards payment of the court fee. Then in that case, after evidences are recorded on both the sides, the court either allows a pauperism or does not allow the pauperism as far as the appeal is concerned. So a regular inquiry, like a lower court, is conducted by the appellate court also. Then, suppose, let us say, the court agrees with the lower court and does not grant leave, then the court has got the power to grant time for payment of court fee. And then, once the court fee is paid, appeal is heard and disposed of according to law. So this is the provision as far as appeals by indigent persons are concerned. It is laid down in Order 44. Then yesterday I was also discussing about Order 47. It is about, that is to be read in conjunction with Section 114 CPC. That is review, but we pronounce it as review. Please bear it in mind. It is not review, it is review. When a judgment is passed against you and the court has not gone into the material particulars or misinterpreted the various propositions which has been cited by you, or there is an error apparent on the face of the record, and the court has not appreciated the facts, taken note of the admissions, contradictions, and inconsistencies, then you have got a right of filing a review before the same court and ask the court to review the matter and hear your arguments. Please remember, review is not a regular appeal. You cannot argue what you have argued in the appeal. Only thing is that the review petition, you will have to point out the inconsistencies, the contradictions, admissions, the case law which has been cited, which has not been properly appreciated by the court, only those aspects which result error apparent on the face of the record, then in that case a review petition can be filed. You cannot convert the review petition into an appeal and argue what you have not argued in the appeal. Please bear that in mind. And review is not a continuation of the appeal. Review is only an incidental proceeding where the court has committed errors, latent or patent, apparent on the face of the record, or there's an error which you can easily detect by looking into the judgment. Then, in that particular case, you can ask the court to review the matter and then hear it accordingly. This is what we have discussed about Order 47. Then, going further, we go to Order 45 or Order 49. It deals about revisions. This again, I point out, this has to be read in conjunction with these sections provided in the Civil Procedure Code. What do you exactly mean by revision? Revision, wherever, please, Order 43 we have discussed. Order appeals against miscellaneous appeals against orders. Suppose, let us say, the appellate court has not heard the matter properly and held it against you, or I take a contingency where your matter from the lower court is not subject, it cannot be a subject matter of an appeal because it has not been provided in Order 43. The only remedy open to you is to find a revision before the Honorable High Court. And revision is a proceeding which you can file it in the High Court and only High Court can hear the matter. Then I'm coming to that question, what exactly is meant by revision? As far as revision is concerned, revision has to be read with section 115 CPC, where it says, where there is exercise of jurisdiction which is not vested with the court. Number one, where there is exercise of jurisdiction not vested in the court. Number two, non-exercise of jurisdiction though vested in the court. And third one is error apparent on the face of the record, that is latent or patent. These are the three conditions on which a revision is maintainable before the Honorable High Court. But please remember, in Telangana area or Andhra area also, previously we used to file it under 115 CPC. Now High Courts have directed no revision can be filed under 115. It has to be filed under Article 227 of the Constitution of India. What does Article 227 of the Constitution say? It says that the High Court has got the power of superintendence over the tribunals below, which is subordinate to it. This, of course, this change came about during the time of Justice Subhashan Reddy, who said people are going scot-free by paying a court fee of only 10 rupees and the revenue of the government is getting affected. So he said that all revisions have to be filed under Article 227 of the Constitution and not under Article 115. And now all revisions, whether it's the Andhra High Court or other High Court, has to be filed under Article 227 of the Constitution of India. What are the conditions which have to apply, sir? Exercise of jurisdiction, though not vested in court. Number two, non-exercise of jurisdiction, though vested with the court. Third one is where there's an error apparent on the face of the record, either latent or patent, then a revision lies and only the High Court can hear matters as far as revision is concerned. And please bear one thing in mind, revision is not a continuation of the suit like an appeal. Revision is only an incidental proceeding where there's an error which you want it to be corrected. So this is what all is dealt with by Order 45 or Order 49 rather. That is the powers of revision of the High Court. And once a revision is filed in the High Court, the procedure followed is it's subject to admission. Whichever judge is in charge of admission, you will have to satisfy the judge that you have got a triable case and that there's a point involved in your revision. And only when your revision is admitted, further hearing takes place. If your revision is thrown out at the threshold at the admission stage, please bear it in mind there is no further hearing at all as far as the revision is concerned. Then you can ask me a question, sir. Suppose I lose the revision, what should I do? You've got the remedy under the Constitution. You can go to the apex court, that is the Supreme Court, and then question the orders of the High Court. So this is what all are the orders part of it as far as CPC is concerned. As far as 50, 51, and 52, orders are concerned, they have no relevance, they need not be gone into, and it is not part of our study. Now, having finished the orders, we go to the sections part of it. And sections also, we only go through some of the important sections. It's not possible to go, to go through every section, please. Here, a new section has been introduced that is called Section 89. Most of you are appearing in arbitration matters or before the Lok Adalat or third party mediation. You say that it is third party mediation, and they're all concisely called as ADRs, that is alternate disputes resolutions. Then the court also introduced Section 89, whereby when the defendant appears before the court, the first step the court takes is they post it for Section 89 settlement. What do you mean by Section 89 settlement? 89 settlement means where the parties will be heard and parties can be questioned whether they want to decide or settle the disputes without going through the trial. Then in that particular case, the court inquires it in detail and then tries to settle the matter at the time of first hearing itself. And one of the best mode of settlement of disputes is referring the matter to a Lok Adalat. Lok Adalat is a body constituted in the subordinate courts as well as the High Court or the Supreme Court to settle the matter across the table without a detailed and prolonged trial. And normally, Lok Adalat matters, what happens is parties are fed up of long delays as far as the cases are concerned, they come to a settlement. And when they come to a settlement, they reduce it in the form of writing and also discuss it across the table and then come to a solution whereby the matter could be decided even without a contest. And one advantage, and please remember, mostly the settlement matters arises out of civil suits, even claims under the motor accidents claims before the motor accidents claims tribunal, where there's an insurance. As far as an accident is concerned, the insurance company also will be called, and then when compensation is asked for, suppose I ask for 50 lakhs compensation, the insurance company says, sir, we cannot bear this exorbitant compensation, please come to a settlement. Then they settle it for 20 lakhs or 25 lakhs, and the matter is thrashed across the table. And once the matter is decided or settled before the Lok Adalat, no appeal lies against the award granted by the Lok Adalat, and the civil courts are bound by the settlements which are arrived at the negotiating table. Or suppose, then why arbitration is also provided, sir? Please remember, it should not be like what is called two cats fighting and the monkey getting benefited. But two parties will be asked to settle the matter across the table. They fix up the agenda, and a third party who is appointed as an arbitrator or a mediator tries to resolve the disputes, intercede the parties. Then you got third party mediation. Sometimes what happens is we all live in a society, we are all responsible citizens, and we are also answerable to the society. And the worst part of it is you should not face what is called social boycott. And sometimes the verdict or the decision given by the third parties who act as mediators has got more effect because of the fear of social boycott. Then you got one more provision called preliminary legal case, that is PLC. PLC means it is filed before the Legal Services Authority, which is constituted for the purpose of settling the matters across the table without going through the process of the court. Then the Legal Services Authority calls upon both the parties to spell out the differences and tries to thrash out the differences between the parties at the threshold itself instead of going to the court. But if the matter cannot be decided by the Legal Services Authority by way of arbitration or counseling, then you have no other alternative than the Legal Services Authority refers the matter to a civil court and they ask you to settle the matter before the civil court. So 89 provision has been provided by amendment of 2002, whereby they say if matters can be settled across the table either by mediation or by lok adalat or by third party mediation, it can be settled. One advantage of going through the section 89 is whatever court fee you have paid, let us say, that becomes refundable by the presiding officer writing to the collector to pay off refund the court fee which has been paid. This is the benefit which the plaintiff gets in third party mediation. Then in Gujarat, there is an institution called Chopal, CHOPAL. I think most of you are viewing television serials or cinemas. In that you find the panchayat or the Nagar Panchayat, which is held across. They sit under the tree, and the elders of the society sit and try to sort out differences. And without the parties going to the court, then that is what is called Chopal. That was followed in Gujarat, and this particular program is also today followed in Dharmasthala, which is located in South Canara. Dharmasthala, you got the temple of Manjunatha Swami. There you got a mutt called Egade Mutt. And please remember the history of Dharmasthala is all matters involving litigations are settled across the table by the jeer or by the head of the mutt. And there is the history shows that no matters have gone to court. So that is the effect of a third party mediation or third party settlement. One advantage of a settlement is that there is no hard feelings among the parties. Parties go happily. And one advantage the plaintiff gets is in case he pays the court fee becomes refundable. So the first step which the court takes when the defendant appears is to explore whether the matter can be settled. That is what is called Section 89 settlement. Then we go to what is called Section 115. You have come at a wrong time. Section 115 of the Civil Procedure Code provides for what is called revisions. Section 115 says, whenever there is error of jurisdiction, exercise of jurisdiction not vested in the court, or non-exercise of jurisdiction though vested in the court, or where there is an error apparent on the face of the record, either latent or patent, that can be corrected by the High Court in revision proceedings. I told you earlier also that revision, as on today of the amendment of the Civil Procedure Code and the directions of the High Court, no revision can be filed under 115. They have also to be filed only under Article 227 of the Constitution, that is the power of the appellate court, the High Court of superintendence over the tribunals below. Then we have got a provision called Section 96. We have discussed Section 96 in detail when we discussed appeals against original decrees. That is a regular first appeal under the provisions of Order 41. We also said it should be read with Section 96. There you mention the cause title and also the provision under which it is filed, and also give the contents of the plaint or whatever it is with the necessary paragraphs, which we have already discussed. So the same is embodied and contained in Section 96, read with Order 41 Rule 1. Then we go to what is called Section 47. Section 47 is a provision which deals with what are the questions which can be discussed or urged before the executing court. Whatever matters can be disposed of or heard by the court which passed the decree, the executing court, though may not be the court which passed the decree, can also hear objections and dispose of the matter. They have the same powers as the court which passed the decree, or the transferee court as you may call it, which executes the decree, and all questions relating to right, title and interest, or questions relating to questioning the decree passed by the court, or all questions which arise incidental in the execution proceedings can be questioned under Section 47. And section 47 is a regular inquiry which is conducted by the executing court or the court to which the decree has been transferred, and the JDR can always question the wires of the order that has been passed in execution and the right, title, and interest which was ignored by the lower court, or where you have got superior rights over the property, what defenses you could raise in execution, they can be raised in section 47 of CPC. Then we go to what is called section 144 of the Civil Procedure Code. This 144, you do not find it anywhere in the orders. Section 144 is titled as restitution proceedings. Suppose the decree of the lower court is set aside or varied or modified by the appellate court, then suppose you have been dispossessed in execution proceedings, you can ask the court to put you back into the same position which you were there before you were dispossessed. Or let us say in execution proceedings, an eviction warrant has been executed against you. You have not received summons in that case. Summons have not been properly served on you. Or let us say it is a decree that has been obtained by fraud, and then you file proceedings in the appellate court, and suppose you succeed in the appellate court. I told you that appeal is supposed to be a continuation of the suit, and then you can ask the lower court to be put back into possession of the property. And when this is availed of, it is called the principle of restitution. Restitution comes from the word restitute. Restitute means restore, or what was done is undone, because when the decree or the judgment or the decree of the lower court is set aside in appeal, that is 144. You may not find it anywhere in the orders. Then you have got 148 and 149 CPC, which has undergone an amendment by the Amending Act 22 of 2002 in 2002, whereby you are given 30 days time to ask for restoration, ask for the condonation of delay or payment of process. Beyond 30 days, courts have no power to extend time. Then you have got they call it popularly as the Dinda Tirismat of Civil Procedure Code, that is section 151. 151 deals with what is called inherent powers of the courts. That is, court has got extraordinary powers where they can exercise discretion in your favor. Under the provisions of section 151, courts are not helpless as far as exercising inherent powers. When you file an out of order before the courts below, you file it under 151. 151 is a provision whereby you invoke the inherent powers of the court. And court has got enormous powers to interfere in all matters where injustice has been done. That is the reason why 151 has been provided. Then we go to section 152. 152, most of us do not know this provision. Wherever there is a clerical, arithmetical, or other errors appearing either in the decree or in the judgment, you can get those errors or mistakes corrected either in the decree or the judgment or in anything, whenever it's arithmetical, clerical, or other errors. But when you file a petition under 152, you will have to file the copy of the petition where the errors have occurred. Then the courts have got enormous powers to correct the errors while exercising its jurisdiction of correction under section 152. Then the question arises, before what time I should file that 152? 153 orders, section 153 says at any time when the error is noticed by you, you can ask the court to correct those errors. That is 153. These are the sections, important sections. Of course, I'm not saying it's exhaustive. It's not possible for me to discuss all the sections in CPC because orders have discussed it in detail. Orders have got an excess with your sections. But there are some sections, there are some orders which do not mention about the sections. That is the reason why I discussed about the sections. Now we come to the amendments of the CPC, which has arisen by the Amending Act 46 of 1976 and as well as Amending Act 22 of 2002 and earlier Amending Act of 1999. First of all, the Amending Act of 1999 was a stillborn child. Why? Because, it contains some draconian provisions. There they say an advocate is socially responsible for any misrepresentations or mistakes or filing a suit without any basis. And they introduced the provision by saying that whenever a suit for injunction is filed, the plaintiff has to furnish security for the cost of the defendant, or the advocate has to answer why mistakes and fallacies have occurred in the petition. Please remember, when we practice on the trial side, we are guided by the instructions that are given by the party. No advocate writes false things. But the question is to make the advocate or the party responsible and the party to furnish security for the cost of the other side is nothing but injustice. And that is the reason the Amending Act of 1999 had a nationwide protest by advocates. They boycotted the courts and they abstained from duties. And ultimately, the 99 Amending Act was a stillborn child. It was not implemented. But the important amendments that have come first is the Amending Act 46 of 1976, whereby they introduced some drastic amendments, whereby they said either the proceedings which are taken for what is called, let us say, attachment before judgment or injunctions or any other relief, they shall not be granted ex parte unless the other party is heard. That is according to the principle of adi alteram partem. That means no man should be condemned unheard. There is an opportunity has to be given to the opposite side to file his counter and hear his objections and also file what is called the documents necessary. And only after hearing both the parties, the courts can grant the orders concerned under all provisions of Order 38 or any other thing, or injunctions under Order 39. That is the reason they introduced a word called conditional attachment. That is, what they do is, they first and foremost is, if you are able to satisfy the court, you have made out a case for attachment, the court orders the other side to furnish security for the suit amount and to show cause why the property should not be attached. Then the other party is given time for 2-3 days to furnish security, and only when security is not furnished or show cause is not shown, then in that case alone the property can be attached. Please bear one thing in mind, that the 1976 amendment is a drastic amendment that has been brought about, where the policy of granting attachment even without hearing the other side has been discouraged, and only conditional attachment can be ordered under the provisions of Order 38 Rule 4 or Order 38 Rule 3 and Rule 4. Any order that is passed without hearing the other side is a nullity and can be set aside as far as in a revision is concerned. Then the other amendment that was brought about by the 1976 code was that ex parte injunctions should not be granted under the provisions of Order 39 without hearing the other side. And even assuming, suppose you press more and you are an advocate who is pressing for the client's cause, then the court passes an order. The court says, no, you have advanced sufficient arguments, I'll pass orders. Then next day you go and verify from the court, what will be ordered is urgent notice will be ordered to the other side. Please remember, do you file a suit only to take urgent notice? That you could have filed an ordinary suit itself. But still, if you insist the court, what the court does is, it passes a via media order called status quo. What exactly is meant by status quo? I discussed earlier in the earlier classes also. It is things stand where they are. Neither you can do anything, nor the other side can do anything. You shall not do anything to the detriment of each other. But please remember, as far as possible, the court should avoid passing status quo orders, because Justice Subhashan, I just quote Justice Subhashan Reddy. He used to say, whenever an injunction application is filed, either the court should allow the injunction application or dismiss the application. But if it passes status quo orders, it's something like, of course, this is the language used by him. It's something like a Koja order. Neither it's a male nor a female. The question is, it's a third person. Of course, I don't want to dilate much about it. But the courts, in order to avoid the liability, are passing status quo orders indiscriminately. And also, the question is, Section 95 was sought to be implemented in a more strict way. That is, suppose, let us say, the court finds that unnecessarily you filed an application in order to harass or intimidate the other side, then in that case, the court can award compensation to be paid to the opposite side under the provisions of Section 95 of Civil Procedure Code. Then we go to one important provision called Section 100. Earlier, whenever you don't succeed in a first appeal, you could file a second appeal before the Honorable High Court as a matter of right under Section 100 CPC. But 1976 amendment had brought about a change whereby they say that as far as the fact-finding authority is concerned, is the first appellate court, and as far as substantial questions of law are concerned, which are formulated and framed, only to that extent the High Court can intervene in second appeal. As far as facts are concerned, you cannot go into facts as far as the High Court is concerned. So that was the amendment which was brought about by the 1976 Code. Only substantial questions of law can be urged and argued as far as the second appeal is concerned. Please bear one thing in mind, it is not available to you as a matter of right. When a second appeal is filed before the Honorable High Court, it is subject to admission. At the admission stage, the portfolio judge who is placed in charge of hearing admissions regarding second appeal, you will have to satisfy the High Court that you have got a substantial question of law which has to be discussed and the matter has to be heard. Only when you succeed in satisfying the court that you have got a substantial question of law, only then a second appeal is admitted at the threshold. And once the second appeal is admitted, then what happens is it is posted for hearing. Then the court calls for the records of the lower court and then discusses the matter or decides the matter accordingly. Please bear one thing in mind, that as far as the substantial questions of law in a second appeal was introduced for the first time in 1976, earlier even questions of fact can be gone into as far as second appeals are concerned. Then, of course, I have discussed Section 151, 152. I'm sorry, Section 151, 152, and 153 also. And 114, I've already discussed. There is a power of review by the court which heard the matter. Whenever there are errors appearing in the judgment, wherever there is an error apparent on the face of the record which has not been properly appreciated, these errors can be highlighted and argued in revision. In review. That is what Order 47 deals. Section 114 read with Order 47 deals with. Then you got one more provision in the CPC called reference. That is Order 49. Reference means where there are contradictory, inconsistent judgments of various high courts, and the judge concerned is not able to decide a point as far as point of law is concerned or point of fact is concerned, then it can formulate the questions and then refer it to the High Court to give its opinion on the questions raised. This is called a reference proceeding, which is very, very rare because no one admits that I do not know anything. But please remember, all of us should know that somewhere the judge also is a human being. He also gets a doubt and he wants it to be clarified by the superior court. Then he formulates a question and then refers it to the High Court concerned, and then ask the High Court to give clarifications regarding the questions raised. Then the High Court gives its answers, and according to the directions given by the High Court in reference proceedings, the court decides the matter. As far as reference is concerned, please bear one thing in mind. You have no right of audience. It is between the lower court and the High Court. Of course, this is very, very rare because every judge says, I know everything. Why should I refer the matter to the High Court? But there are some points because, unfortunately, what is happening is the courts are not following the judgments of the Supreme Court. They say, what is Supreme Court? I am not going to follow it. Even though you have cited it, they only write a line saying that I am not convinced with the judgment of the Supreme Court. Of course, no judge dare say that I'm not convinced or I don't want to follow the judgment of the Supreme Court. Or sometimes when High Court judgments are also cited, the courts say they do not apply to the facts of the case. But if you go into the details of the judgment, it squarely applies to the facts of the case. Then these are all the cases. That's the reason why reference proceedings are provided in civil procedure court. So this is and then I think there are some doubts expressed regarding garnishee proceedings. When I was discussing about orders, you raised a question regarding garnishee proceedings. Please remember the word garnishee is not an English word. Garnish is not an English word. It is taken from Urdu. What do you exactly mean by garnishee? Garnishee is defined as debtor of the debtor who is called a garnishee. For example, suppose let us say I got a fixed deposit with a particular bank, and that is the money not belonging to the bank, it is the money belonging to me. I invested it in a bank for my interest part of it and also for future purposes. Suppose I'm indebted to the plaintiff and the bank is about to pay the money due under the fixed deposit and on maturity, or let us say some amounts have to be paid by a third party to the debtor concerned. The person who is a decree holder can apply to the court under Order 21, Rule 46, saying, sir, please attach those amounts which are lying with the garnishee. Garnishee is defined as a debtor of the debtor is what is called a garnishee. And please remember, straightaway the court cannot pass a garnishee order. Once a garnishee proceeding is initiated, it is a duty of the court to issue notice to the garnishee to show cause why the amounts due and payable to the party should not be deposited in court. Then, pursuant to the notice issued from the court, the garnishee has got a right of filing his counter or opposing the petition. Then, the garnishee is heard and the matter is discussed and settled across the table, and the garnishee is directed to deposit the money into the court. He is not interested who should get it. Then, subject to the result of the proceedings, the money will be paid accordingly. So, any garnishee proceeding issued without notice under Order 21, Order 21, Rule 46, B or C is illegal. It's a nullity, and it can be set aside when subsequent proceedings are taken before the Superior Court. Then one more provision is there. That is Section 46 of the Civil Procedure Code, which talks about precepts. Precepts. Please remember, precepts is letter of request from one court to another court to do a ministerial act on its behalf and then report to the court. For example, suppose the courts are located at Vijayawada and proceedings are taken, but the property is located at Hyderabad. Then a property is located at Hyderabad and proceedings are taken for furnishing security, then it's a duty of the court at Vijayawada to issue a letter of request to the court at Hyderabad, preferably the principal district court, asking it to do that thing which they could have done. Then in that case, the court to which a letter is addressed has to perform those acts which the court of the initial instance can do. This is what is called a precept. Here, let us say, I just give you an example. Suppose, let us say, you are asking for furnishing security from the different, and the property which you want to attach is a mobile property that is in the form of a Matador van. And at the time when the suit is instituted, the Matador van was at Hyderabad, but the person who has suffered a decree has shifted it to Nalgonda. Then the question arises, can the court at Hyderabad or Secunderabad, whichever it may be, can it attach a movable property which is not located within its jurisdiction? Then what it does is it issues what is called a precept order to the principal district judge of Nalgonda to perform a ministerial act and to attach that Matador van and then make it a charge of the court as far as the decree is concerned. Here in Telangana, this was the earlier practice followed. That precepts was very much applicable in Telangana. I have seen by experience that this particular provision is only applied in Andhra area. In Telangana, it is almost had a still death. It is not any more applicable in Telangana areas. Then you got a provision called 136 CPC, which says that a judge sitting at Vijayawada cannot call for security from the defendant as far as the decretal amount is concerned, and then ask, and in case the defendant does not furnish security, cannot attach a property at Hyderabad. And if any such order is passed, it is a nullity because it's against the principles of 136 Civil Procedure Code. In such circumstances, you can always file a petition to raise the attachment and also question the attachment or get yourself impleaded when you're not a party, saying that your interests are involved and the court has no other alternative than to hear your objections and dispose it off accordingly. Then, I think I've discussed about inherent powers of the court. Then correction of clerical errors or typographical errors in 152 and 153 says at any time it can be corrected. These are the provisions. Now we go to the important provisions of civil rules of practice. Civil rules of practice, most of us do not know that there is a law called civil rules of practice. Most of us only follow CPC and we forget civil rules of practice. In civil rules of practice, civil rules of practice, we have got what is called some important provisions. First and foremost is Rule 28 Civil Procedure Code. Whenever an amendment petition is filed before the court, or wherever a petition is filed under Order 1 Rule 10, in plead parties, it is mandatory that whatever consequential amendments you have to make in the pleadings, you have to mention it in the affidavit itself. You cannot file a separate petition for consequential amendments later. Earlier we used to do it, but now it's not permissible unless a paragraph is devoted on the consequential amendments, cause of action, prayer, so on and so forth, which have to be corrected. Then, unless you mention it, your petition will not be numbered. That is what is called consequential amendments under Rule 28. Then we have Rule 32 and 33 of the Civil Rules of Practice, which mentions about where a suit is filed through a general power of attorney holder and the power of attorney is filed into the court, it is mandatory that the power of attorney holder has to file a petition, an interlocutory application that he is the GPA holder of the petition plaintiff and that he has been authorized to file and prosecute the case or defend the case for and on behalf of the party, and that the power of attorney is still in a subsistence, it has not been cancelled or revoked, and please give me permission to file the suit or prosecute the suit or defend the suit as a GPA holder of the principal. So, as far as Rule 32 and 33 is concerned, permission petition is absolutely mandatory when the matter is prosecuted or defended by a power of attorney holder. That is Rule 32 and 33. 33 applies in a case or a scenario where the suit is filed by the party in person. But if the suit is filed by the advocate concerned on behalf of the plaintiff, it is Rule 32, represented by the GP order, of course. So the question is, Rule 33 will apply in a case where the party or the agent appears in person and not otherwise. So Rule 32 and 33, permission of the court while instituting a suit to file it through the GPA is absolutely mandatory. Then we go to what is called Rule 125 to 127. What does it say, sir? The common complaint which is made by the defendant or the opposite party is, sir, I've received the summons, but I have not received the plaint, I have not received the petitions, I have not received the documents. And in spite of asking the other side has not furnished copies. Shall I tell you how this mischief occurs, sir? When we pay the process without, and you pay the process along with the summons for settlement of issues, and along with that you also enclose the copies of the petitions or copies of the print. But what the Nazarat does is it deputes the process server to serve the summons on the opposite side. I think in most of the courts, whether it's Andhra area or Telangana area, you can find in the Nazarat that the process server carry only a small black bag. And if you open the black bag, you will only find the summons in that. As far as the print copies or the petition copies are concerned, they'll be thrown in the dustbin. The copies will be missing. Or the documents which you furnish also will be missing. The real problem comes to you when you appear for an institution where there are 15 parties or 20 parties. Unless you, please remember, civil rules of practice says you shall not take the other side by surprise. All the cards will have to be laid on the table, and all the papers which you file into the court, copies will have to be provided. But please remember, it is not our fault, but it's the fault of the Nazarat, and the process server, he only carries the summons, and the other papers are thrown in the dustbin. If you go to the Nazarat, be it the Telangana courts or the Andhra courts, if you just inspect the dustbin, your papers will be lying in that. And the process server only files a report. And please remember, without furnishing copies, your suit will not be numbered. It's absolutely mandatory that copies of the plaint or copies of the petition or copies of the material papers have to be given to as many respondents or defendants as the case may be. Without that, the process will not be issued or your suit will not be numbered. But suppose, let us say, the copies are misplaced. Then in that case, the other side, who has not got the copies, can file a petition, can file a memo, He can file a memo under Rule 125 requesting the court to direct the opposite side to furnish copies. Then under Rule 126, the court acts on the memo filed by the party and passes an order directing the opposite side to furnish copies. Then Rule 127 is the consequences of not following the orders of the court. Suppose the copies are not furnished in spite of the directions given by the court, then the court can reject those papers and even reject your plaint also under all circumstances, or the documents will be shut off and will not be taken into consideration. So these are the various factors that has to be borne in mind under Rule 125, Rule 126, and Rule 127. Then the practical problem which is faced by most of the advocates is when a suit is decreed, let us say, you are the successful party, you are not bothered about it to obtain copies, you only file a CA. But as far as the aggrieved party is concerned, that is the defendant or defendants as the case may be, they are interested to take the matter further by filing an appeal. Then in that case, they also file a CA, a copy application as you may call it. In the High Court, they call it a CD. That is copy deposit order. There, what happens is normally when you go to the copying department, a CA number is given to you. And when the CA number is given to you, it is entered in a register called CA register. Once it's entered in the CA register, the originals have to come from the court which has passed the decree or the necessary papers have to come from the court where the suit is pending. And that court takes its own time in sending the originals to the copying section. And please remember, judgment is passed or decree is prepared, it's subject to so many ifs and buts. The judge has to correct it, judge has to put his initial, fair copy has to be typed, fair copy has to be signed, fair copy has to be sealed, and then the judge has to give his final approval of that. Only then the originals are ready. And then the originals arrive in the copying section. And under the rules governing grant of copies, 3 days time is given for depositing the charges. Those days we used to what you call we used to pay the charges in cash. Now cash is not being accepted in the copying section. In I've seen Andhra area, you have to deposit. Affix as many stamps as far as the copying charges are concerned in a paper. Write the CA number, date when it was filed, date when the charges were called for, date in which it has been deposited, and you as an advocate sign the necessary papers and then file it before the copying section. And the copying section has to endorse in the CA register that the charges were called for on a particular day. 3 days time was given. The charges were deposited on so and so date, and it takes its own time in granting you the certified copies. This difficulty we had in the earlier days. I still remember in 1972 when I was enrolled. Those days, printed copies also were sought to be filed, and along with the certified copies, you're supposed to file printed copies. And printed copies, the court ఆస్థాన విద్వాన్లాగా ఒక్కడే ఉంటాడు ప్రింట్ చేసేవాడు. వాడి దగ్గర bundles and bundles of papers will be there. Sometimes it takes 1 year or 1.5 years to print the papers. And by the time it comes to the copying section and you are entitled for the copies, Janagana Mana will be over as far as your case is concerned. So what they did later, they said they introduced certified copies. Certified copies is those days we used to have folios. As far as certified copies are concerned, I think it was 60 paisa or 70 paisa folios which were printed and given to you. And in the folios they used to manually type the judgment or type the decree. Then please remember, things will not remain as it is. Then what happens is Xerox machines came. When the Xerox machines came, straight away mechanically they insert the paper in the copying machine in the printer and take out the copies mechanically, and then they put their seal and put their signature and grant you. Please, so many ifs and buts are there, sir. How a junior advocate suffers in the copying section, I know, because I also passed through that stage. Then on the day when it has to be signed, the superintendent of the copying section will be on leave, or no in charge will be there. It takes its own time to be signed. Then in that particular case, you can't get the copy once it is signed. And it will be in the down, if you see, certified as true copy. Then the seal of the court is put. Here, why I'm trying to tell you all these things is, once the copy application is filed, it is your duty to pay the charges on time. And if you don't pay the charges within 3 days, as per the rules, your CA will be struck off for non-payment of copying charges. The disadvantage which you will face is, please remember, no person will file the appeal within till the last day. And mostly your client comes up or lands up only on the last day. You are asked to prepare the appeal without the copies. Please remember, without the copies, it is very, very difficult for you to prepare an appeal. Then most of us, your junior, unfortunately, the juniors are kept in charge as far as the copying affair is concerned. They go to the copying section every day, and only stock reply you get is originals have not come. One fine day, that is Peddapuli Samacharam antaru. Ye rojaithe me polelo, that day copies will be called for, charges will be called for. You don't deposit the charges, and sometimes negligently for 10-15 days you keep quiet. After that, when your senior takes you to task, you file a wide CA. Wide CA means already you have filed a CA in that you are called for charges. I'm filing a wide CA. Please remember, under the Limitation Act, once time has begun to run, it does not stop. Time and tide wait for no man. Then in that particular case, what you have to do is, in case you want to keep your client happy and keep your CA alive, you file a petition under Rule 201. Please underline this word, Rule 201, Civil Rules of Practice. Ask for restoration of the CA, pay the necessary charges, and the application has to be filed in an interlocutory form before the principal district court. And the principal district court normally Once such an application is filed under Rule 201 and sufficient cost has been shown and charges have been paid, he orders for restoration of the CA. One advantage of the CA getting restored is it will be taken as if the charges has been paid on time and the delay in paying the charges has been condoned, and the copy as and when it is ready, that period which is taken by the copying section to grant copies will be excluded for the purpose of filing an appeal. So Rule 201 is a provision which provides for restoration of a dismissed copy application, please. Then most of you are appearing in money suits or motor accident claims and the check is deposited into the court. There is a provision called check petition. That is Rule 230 to 232 are the civil rules of practice provides for a check petition being filed. Please remember, nowadays the printed forms have made our advocates lazy. Why? Because everything fill up the blanks alone. Then now when the information technology has come, you have got the laptops and the desktops also. You have got the proformas. You just fill up the proformas and file it into the court. And you are supposed to file a petition accompanied by an affidavit and along with a memo of part satisfaction or full satisfaction, and also what is called payment schedule has to be provided with the receipt, signed by the party and signed by the advocate. And once that is filed, court normally does not grant you the check immediately. They order notice to the other side. Other side has to be given notice, and the other side comes and appears. And then suppose you are entitled for that amount, court does not pay you cash. Don't expect cash to be paid by the court. Court does not have impress cash to pay to you immediately. What the court does is, under the seal and signature of the judge, a check is prepared and the check is given to the party concerned. Earlier, the advocates used to have a gala time over the checks because checks used to be issued in the name of the advocate. But the Supreme Court has come out with a heavy hand saying that no check should be issued in the name of the advocate. Because in motor accident cases, experience has shown, suppose the party is entitled for 60 lakhs compensation and the check is given in the name of the advocate, what comes into the hands of the party is only 10 lakhs. 50 lakhs is pocketed by the advocate. And parties come and complain, sir, we have not been given the check at all. The advocate says that 50 lakhs is towards my fees. That's why the Supreme Court has laid down guidelines by saying whenever a check is issued, it is a duty of the court to ask the party to provide the passbook also where an account is held, a passbook as well as the Aadhaar card, Xerox, so that the amount which is granted by way of that check goes directly into the bank of the party concerned who is entitled for that amount, and the party gets the amount. But of course, don't underestimate our advocates. What they do is they take a promissory note or they take an agreement that as and when the check is granted, you will be paid 20% or 30%. And they even take a promissory note from the party that this amount will be paid. But please remember, taking a promissory note is not enforceable. Perhaps you know that also, because it is against the Advocates Act. An advocate cannot turn himself into a creditor and indulge in certain things. Then Rule 230 to 232 is check petition. Then after that, you may ask your what is the provision under which court fee is paid as far as caveat petitions are concerned. Court Fees Act, either Andhra Court Fees Act or the Telangana Court Fees Act. Telangana Court Fees Act is nothing but adaptation of the Andhra law, which says it should be filed under Rule 295, Civil Rules of Practice. You search the Court Fees Act, nowhere in the Court Fees Act there is a provision mentioned for payment of court fee as far as caveat petitions are concerned. So these are the important rules as far as Civil Rules of Practice is concerned. Then we go to the amendments to the CPC as per the Amending Act 22 of 2002. The first amendment that was brought about was introduction of quicker and expeditious serving of summons on the opposite side. That is, earlier, Order 5 used to contain that summons were only provided 3 times. One is summons through court, summons through registered post, and then substituted service of summons. But they found that most of the delays which occur in court is because of non-service of summons. So now they are provided saying that you can send the summons by speed post, courier service, EMS, that is electronic mail service, WhatsApp, email, so on and so forth, which is quicker in serving it on the other side. But one important thing you must remember is when you send it by email, or when you send it by WhatsApp, or when you send it by courier, you are supposed to file the tracking report. Tracking report is whether the article has been delivered to the opposite side or not. Unless you file that, the court will not accept such type of service. That is the first amendment that was brought about in Order 5. The second amendment that was brought about was by introduction of a new rule, Order 6, Rule 1, which says all plaints or appeals have to be filed in duplicate. Earlier, we used to file only a single copy, that's the original. But now we are supposed to file in duplicate. Can you give me the reason why? The reason being that whenever the judge hears the arguments, he makes his markings in the duplicate copy. That is the reason why it is made in duplicate. And nowadays, when we are in the information technology, the plaint or the appeal which you file is scanned in the computer. That's the reason why you are supposed to file an extra copy for scanning purposes. That is what is called computer copy. Then after that, you are all, please remember, unfortunately, what is happening is the sections do not know the law. They are SSLC or 10th class or 12th class, except somewhere you find law graduates who are manning the superintendent's position. There they say, sir, you have not filed the verification affidavit. Please remember, where is the question of verification affidavit in an appeal, sir? Verification appeal comes only in a suit, not in an appeal. But they try to enter into an argument with you, verification affidavit has to be filed. They also insist on implementation of Order 6, Rule 14. What is Order 6, Rule 14, sir? An affidavit showing an affidavit filed by the party showing that the addresses of the parties given in the plaint are true and correct. The addresses are extracted by party signs. Then the next amendment that was brought about was verification affidavit. That is Order 6, Rule 15, bracket 4. I think in criminal law, you know, once a hanging sentence is passed, you pass a death sentence, the noose has to be put on the neck of the culprit, and then he has to be hanged. Earlier, what happened in one of the instances, the noose was put on the neck of the person who was to be hanged, but the noose was not correctly put, and the executioner wanted to put the noose again. But the court said, you can hang a person only once. You cannot hang him again. So they said, now it has been amended, whereby they say, hang until he is dead. But చనిపోయేదానికి వాడు escape అయినా కూడా వాడు చనిపోయిన వరకు వాడు ఉరివేయండి అంటారు. That is what the criminal law has changed. In the same way, as far as civil law is concerned, why verification affidavit has been provided is, it is for the protection of advocates. Please remember, don't believe your client. Don't trust your client. At the inconvenient position, he says, అరే బాబు నువ్వు రాసావా ఇదండి, నేను రాయలేసా, మా ప్లీడర్ గారు రాశారు అంటే ప్లీడర్ అన్ని తెలుసా, నేను చెప్పిన మీదనే కదా ప్లీడర్ రాసింది. So that is the reason you mentioned in the verification affidavit that the plaint has been drafted according to the instructions and according to the directions of the party. The party himself says, I have given instructions to the party and it has been drafted according to my dictates. And the allegations of the averments made therein are made with full restraint and responsibility. And then the party signs. That means the party puts a noose around his neck and also puts it tight so that he does not escape. An advocate escapes because what you have written is only what has been instructed by your client, not otherwise. That is the reason why Order 6, Rule 15, bracket 4 has been provided. Then the next amendment that was brought about was filing of the documents subsequent to the suit. That is, earlier, under the old code, we used to follow Order 13, Rule 2, be it the plaintiff or defendant. But under the amended code of 2002, when the plaintiff files subsequent documents, they are all filed under Order 7, Rule 14, bracket 2. Order 7, Rule 14, bracket 2. And whenever the defendant files documents subsequent to the filing of written statement, he files it under Order 8, Rule 2A. Not under Order 13, Rule 2. These are the two amendments which were brought about in the law of pleadings. Then we go to what is the time within which a written statement has to be filed. A new rule has been incorporated, a new rule called Order 8, Rule 1, which says that all written statements will have to be filed within a period of 30 days from the date of issue of summons. Not on the date of appearance, but 30 days from the date when the summons are served on you. Suppose you don't file the written statement within 30 days period, then you got the second provision. Or 8 Rule 2, the court can extend time from time to time, not for a period not exceeding 90 days. But again, when the Supreme Court was asked to interpret this provision, whether 90 days is mandatory or not, the Supreme Court, in one of the leading cases of 2005-4 SCC, has clearly laid down that the period of 90 days is only obligatory and not mandatory, except in commercial courts. In lower courts, you can always file it even after 90 days, but the other side will be compensated by costs to be paid. So the lower court cannot insist that the written statement should be filed within 90 days. That is the Supreme Court judgment. Then we say what you call alternate pleadings. Alternate pleadings. That means whenever subsequent acts arise, you want to bring it to the notice of the court, or you want to explain certain, clarify certain vague statements made in the written statement, you are entitled to file into the court what is called rejoinder. Rejoinder is filed under the provisions of Order 8, Rule 9 CPC, and subject to permission of the court under Order 8, Rule 6A. Then whenever you want to ask for permission to raise counterclaim, you have to raise it under Order 8, Rule 6A. Permission has to be taken. Then we go to the next amendment which has come through is Order 18. Order 18 speaks about what is called, please remember I told you that some of us are good in writing, some of us are good only in talking, some of us are good in talking, that's all. Whether it makes sense or no sense, we go on talking, that is blah, blah, blah. But there are some people who are good in writing. That is sometimes what happens is because some of us come from vernaculars, we are not that thorough with English. English is not our mother tongue. So some people are very, very fluent as far as Telugu is concerned. They are very good writers. Then in that case, a provision is provided, that is Order 18, Rule 2, Bracket 3, where after the hearing is culminated, the parties argue the matter, court restricts the time also within which the arguments have to be completed, directs the parties to file their respective written arguments, and once the arguments are heard, 7 days time is granted for filing written arguments. And once you as a plaintiff files a written argument, the opposite side will be given 7 days time to file its written arguments along with the case law that has been cited. Can you tell me, sir, what is the advantage of filing written arguments? Court cannot. Please remember, if you see, when arguments are heard, court will be just sitting like this, as if listening to a lullaby. The mother trying to make the child sleep. And sometimes suddenly they wake up and say, Yemanarandi. That means Ramayana Vinesi Ramaru Sita Yamautan. And sometimes judgments are also like that. So that is the reason to see that the judges are alert. Judges give a proper judgment. They hear a matter in a transparent manner. Written arguments has been provided under Order 18, Rule 2, 3, that is by way of an amendment. And the similar provision you got in CRPC much earlier to the amendment to CPC, that is 314 of CRPC, which says that written arguments can be filed even in criminal cases. Then one more amendment that has come through is Order 18, Rule 4 and 5, which says all evidences in chief are to be filed. All evidences in chief has to be filed. All evidences in chief shall be filed, not shall, has to be filed. Shall be filed by an affidavit. Shall be filed. Shall, the word shall. And once the affidavit evidence is filed, please remember how it has to be drafted. Also, High Court circular is there. The entire plaint need not be copied. Only sum and substance of the plaint what you have testified before the court while giving evidence, only that has to be mentioned. Please remember, most of our advocates, we are so lazy. We go to the typist and say, please type out the evidence affidavit. That man types the court fees, he types the jurisdiction, he types the prayer, so on and so forth. That is not the criteria. The sum and substance of what you would have deposed before the court is what is called evidence affidavit. And then evidence affidavit, whatever documents are there, it's a duty of the court to mark those documents. And then the cross-examination part of it, either the court can record the cross-examination or delegate its functions to a junior advocate to record the cross-examination. It is one of the sources of income for all junior advocates. But I was the first person who wrote an article when this provision was introduced by saying that the Pandora's box of confusion has been raised by providing this provision. Why? Because a junior advocate is not equipped with that knowledge to know what is a suit document and what is an evidentiary document. At least remember, the law of evidence says it is a privilege of a cross-examiner to confront the witness with documents, and they are called evidentiary documents, and they need not be filed at the time of filing the written statement. And then they are unable to decide it. Then what happens is there is no seriousness in a commission proceeding. I said, put up a cigarette system and advocate both. Or it says, pan ka leke aata hu. After half an hour, I'll be breakfast kar leke aata hu. It will be in the midst of cross-examination. By the time seriousness is lost, and the demeanor of the witness is also not noted by the commissioner. So these are all the fallacies or drawbacks as far as this particular provision is concerned. Then the next amendment that was brought about was Order 20. Order 20 says, at what time a judgment has as far as Order 20 is concerned, the judgment has to be passed immediately or reserved for judgment and should be passed within a period of 14 days and not later than 14 days. That was before the amendment. In 2002, the legislators felt our judges are overworked. They've got a lot of work and they're doing nothing but work. Then they said they amended Order 20 by saying that a judge can pass a judgment within 30 days after reserving it for judgment. Then, of course, here also mischief is committed by the court. I think you know it. The court, for inexplicable reasons, says that the matter is reopened for further arguments. Then it instigates the parties or the advocates and a reopening petition Inka 30 days of now. Like that, for 6 months or 1 year, a judgment is not passed. So that is the reason 30 days period has been now mentioned instead of 14 days. Then the question arises, when I have to file an appeal under Order 41 or Order 43, I have to file a copy of the decree. But now, getting a decree sometimes is very, very difficult. Court takes its own time in passing and framing the decree. Then in that case, they said, you need not wait for the copy of the decree while filing an appeal. You can file an application to dispense with filing of the copy of the decree. And then as and when you obtain the decree, you can file it in the court. Suppose, let us say, 4 suits are clubbed together and a common decree is passed. Then they say, though you have to file 4 appeals, but decree you can file it in 1 appeal, you need not file it in the other appeals. Then the other amendment that was brought about is 148 and 149. The maximum period for continuation of delay is 30 days. Then, as far as Order 39 is concerned, Order 38 is concerned, court cannot pass an ex parte order of injunction. Court has to issue notice to the other side, and unless it issues notice to the other side, an attachment cannot be ordered or arrest cannot be ordered. Then the next amendment was Order 39, which says ex parte injunction should not be granted unless the party is heard and notice is issued to the other side, and the other side is given an opportunity of filing the counter and the documents which supports his defense. And then only when he is heard, a order is passed. Then the other amendment which has come is filing an appeal under Order 41 when 4 suits are clubbed together and the common decree is passed. You need not file the decree in every appeal, but you can file the decree in 1 appeal and the other decree, other appeals, you can say it has already been filed in so-and-so appeal. These are the various amendments that have taken place by the Act of 2002, that is Amending Act 22 of 2002. Am I making myself clear to you, please? After this, your CPC is deemed to be over, and in the next lecture, I will be dealing with the important articles of the Limitation Act. Section section important section just check.
Sir, నేను అడ్వకేట్ అవినాష్ ఇంకోటి ఒక డౌట్ అడగొచ్చా సార్?
సార్ ఒక్క నిమిషం సార్. అవినాష్ గారు చిన్న అనౌన్స్మెంట్.
ఓకే.
Yes, Mr. Avinash.
సార్ ఒక్క నిమిషం.
Please wait.
చిన్న అనౌన్స్మెంట్.
Please wait.
Every day classes will go on as per the schedule, and the contract acts, family acts, and even sir as to amendment acts will also be conducted on a daily basis. So please don't miss the opportunity. Even he is trying to teach CRPC also. So please don't miss any kind of opportunity. Thank you. Sir, over to you.
Thank you, sir.
Yes, Mr. Avinash. Mr. Avinash.
Sir,
Yes.
sir, I have a doubt, sir.
Yes.
I am a practicing advocate at City Civil Court, High Court, and other various courts, sir. I have enrolled in the year 2007, sir.
Right.
I have obtained merit, a few degrees, I can say, not many. But once in the year December 2023, I got a problem with my client, sir.
Right.
I have obtained the decree from the City Civil Court, and I have given the copies of judgment and decrees to my client.
Right.
And he promised me to pay the fees.
Right.
But thereafter, he never turned up, sir. I made him number of calls, but he never turned up.
See, one thing
So
is,
how
yes,
to
yes,
how
I
to
tell you.
recover fees from the client?
Yeah, I
And
tell you, sir, the
sir,
Supreme
why
Court-
I am raising this question is there are many of our friends advocates who have enrolled recently and who are not aware about how to tackle with the fee structure from the client, sir. Therefore, I am raising this doubt, sir. Please kindly
The Supreme
don't mind, sir, for
Yes,
raising this
the
doubt,
Supreme
sir.
Court has interpreted this particular position by saying that an advocate has no lien over the file or the documents. Only thing is, like an ordinary creditor, he must file a suit to recover his fees. He must file a suit.
Sir,
File a
sir,
suit for recovery.
Sir, there won't be any type of writing agreement or
Even
like
if it's
any
not there,
written
Sir, even
part
if
of
it's not
agreement
there,
between the client.
Even if it's
Sir.
not there, seeing your diary, how many hearings you have attended, how you have conducted the case, how you have argued the matter. The judgment also says that you argued the matter, and so many hearings it had taken. Then for the fees, I stipulated so much. Client has not paid me anything. Please direct it. And when I asked him for the fees, he took the judgment and copy and just went away. I even handed over the file to him, but he has not paid me the fees. Please direct him to pay the fees. It depends from the.
Oh.
Please remember, as far as I am concerned, I collect the fees first before I take up a case. At least 50% of the fees to be taken, sir. Don't be fooled by a client, because a client tries to fool you by giving you all rosy pictures. आपके पास है
Yes,
तो
sir.
क्या, मेरे पास है तो क्या है, पूरा बैंक में है समझो. And that is the reason why we advocates also turn dishonest. When we quote the expenses, we quote a higher figure so that when the fees is not paid, it's adjusted there. And that's why you see most of the
Correct.
claims, the court fee paragraph will be empty. What court fee is paid? But please remember,
Correct, sir.
nowadays parties know everything. They take out Xerox of the receipt also and keep it with them.
Yes, sir. Yes, sir.
But Supreme Court
Yes,
has
sir.
interpreted you have no lien
Sir.
over the file or the documents. Only thing is you have to file a suit for recovery of your fees.
Yes. Sir, one more thing, sir. Can we collect the entire fees earlier before means at the time of admission of the suit? Can we collect entire
Please
fees
remember,
from the
I have
client?
not seen a client paying the full fees in the initial stage itself. Even if
Yes, sir.
even if you appear for a bank does not pay the
Yes.
fees first. They pay 1/4 of
Yes.
the fees first. 1/4 is paid at the time of framing of issues. The other balance is paid when you take the decree. At that time, your entire balance is paid, and execution fees will be paid at the time initially for some amount, and then after that, the entire execution fees will be paid to you after the decree copy is obtained and you execute the decree, please.
Yes, sir. Thank you, sir.
I have not seen any client paying me the full fees, sir. If anyone,
Yes,
the
sir.
advocate is telling you I collect the full fees, he is only fooling.
Yes, sir. Yes, sir. Thank you, sir.
Because
Thank
the profession has become so overcrowded now.
Yes, sir.
And another thing is, please don't quote the fees in the corridor. Ask your client to come to your office, to talk to him,
Yes, sir.
and better to take an agreement. This is a fees agreed. And you will pay 50% now, 50% later. That will give you strength when you file a suit also.
Yes, sir. Thank you, sir.
Right.
Thank you, sir.
Yes, next please. What about Gauzia? You don't have any doubts today? Gauzia from Madanapalli.
Sir, good evening, sir.
Good evening.
Sir, I have a doubt in criminal law, sir.
See, criminal law I'm not dealing with, please. Don't ask criminal law now.
Yes, sir. Thanks.
We are coming up.
Aruna, please unmute your mic.
Sir, good evening, sir.
Good evening.
Sir, once explain precept, no, sir.
Precept is an order called letter of request from one court to another court to do a job for it when it is outside its jurisdiction. I told you the example also. Suppose a suit is filed in Vijayawada and the property is located at Hyderabad. The judge sitting at Vijayawada cannot attach a property at Hyderabad because it is beyond its territorial jurisdiction. Or a contingency arises at the time when the suit is filed, the movable property, like what is called a Matador van, he was at Hyderabad. But subsequently, in order to avoid the execution, the van is taken to Nalgonda. The court at Hyderabad cannot attach a movable property located within the jurisdiction of another court beyond its reach. Then, in that case, it issues a precept order. Addressed to the principal district judge of Nalgonda to do the job what this court would have done, and that court deputes the bailiff and executes the decree accordingly. That is what is called a precept. Precept means a letter of request. Again, it's subject to section 136 CPC also, which says that the court has no power to attach a property which is beyond its jurisdiction. That is what 136 lays down.
Okay, sir. Thank you very much.
Yes.
Shall you explain the garnish, sir?
Pardon? Garnishing. I expected this question to be put. That is, garnishing proceedings only can be taken in execution proceedings, not in a suit. That is Order 21, Rule 46, which says garnishi is not an English word. Garnishi is a Urdu word. That means a debtor of a debtor is called a garnishi. For example, you have invested some amount in fixed deposit before a bank, and on maturity, the bank is supposed to pay you that amount, whatever is the matured amount. But you are indebted to the plaintiff and execution proceedings are taken, and the fixed deposits amount is liable to be paid by the bank. Then you ask the bank to show cause why that fixed deposit amount due and payable to his customer should not be deposited in the court towards the satisfaction of the decree. Then in that particular case, notice is issued to the garnishee or the debtor of the debtor to show cause why the amount should not be deposited. Then after the debtor of the debtor, that is the garnishee, shows sufficient cause, the matter is heard across the table and an order is passed. And once the garnishee is directed to deposit the money into the court, whatever is the maturity amount, he does not do so, he can be made liable for contempt also. But all proceedings taken in execution under Order 21, Rule 46, even the garnishee can file an appeal before the High Court and contest it. And without issuing notice to the garnishee, no order can be passed in execution. But Order 21, Rule 46 applies only to executions and not to suits. Am I making myself clear to you, please? Or it can also be the case of a landlord and tenant. Suppose the tenant has to pay you the rents. You can ask the tenant to deposit the rents into the credit of the suit and to show cause why rent should not be deposited, and the rents which are deposited into the court, and if the garnishee shows sufficient cause and is heard, then an order can be passed. Instead of paying to the landlord, the tenant can deposit that money into the court, and that money will be paid to the decree holder as per the execution proceedings fees. That is what is called garnishee proceedings under Order 21, Rule 46A, 46B, 46C, and 46D. Am I making myself clear to you, please? Next.
Okay.
Next.
Sir, what is the difference and what is the between pecuniary jurisdiction and territorial jurisdiction?
Pecuniary jurisdiction here, when we are in the metros, it is covered under the City Civil Codes Act of 1972. But if you are in the districts, it is governed by the Civil Codes Act. City Civil Codes Act, when it was promulgated in 1972, the jurisdiction, that is as far as pecuniary means, you have got a three-tier compartment. That is, you have got the district court at the fulcrum. Below the district court, you have got the senior court, and below the senior court, you have got the junior court. Junior court is supposed to be the lowest court. Earlier, in the old court, the pecuniary jurisdiction for a munsif was only 5,000 rupees. Above 5,000 till 20,000, it was the sub-court. And above 20,000, it was the district court. Sub-court means now you call it senior court. Then, yes, 20 lakhs up to 50 lakhs, it was the district court. And above 50 lakhs, it used to lie to the high court. But now, according to the amended laws, pecuniary jurisdiction has been raised. Now a junior court is entitled to hear all matters up to limit of 20 lakhs. 20 lakhs.
Yes, sir.
And after 20 lakhs to 50 lakhs, it's the sub-court or the senior court. And above 50 lakhs unlimited, it is a district court. So all matters till appeal is thrashed out at the grassroots level. The reason behind this amendment was the High Court does not want to hear first appeals. They say we are all pundits as far as interpreting constitution is concerned. After all, this appeals are only small things for us. Please remember, appeals is not that easy. That's why they washed off their hands by increasing the jurisdiction. Then territorial jurisdiction, you asked me one question. That means there they call it as, that is where the cause of action is approved within the periphery of the local jurisdiction. It is what is called territorial jurisdiction. Suppose, let us say, the Pramsar note is executed at Secunderabad, only the courts at Secunderabad will have jurisdiction. Or suppose the Pramsar note is executed at Nalgonda, only the courts at Nalgonda will have jurisdiction. Suppose you have got a charge over the immovable property, you have filed a mortgage suit and the property is located at Nalgonda, though the parties stay at Hyderabad, you can file a suit only in Nalgonda. That is wherever the property is located, not otherwise. Then we have got another type of jurisdiction called subject matter jurisdiction. Now we are in an era of specialization. Most of the jurisdiction of the civil courts are being taken away. You know, there is a provision in the CPC called Section 9. All suits of civil nature can be filed in a civil court unless expressly barred. For example, you have got the matters arising in the Housing Societies Act, Cooperative Societies Act, Industrial Disputes Act, Chit Funds Act, or let us say arbitration, conciliation, etc. are the matters arising under the family court jurisdiction. You cannot file civil suits. You have to go only to the special courts concerned. That is what is called subject matter jurisdiction. Of course, by oversight, I've forgotten two more important provisions which have to be discussed. I think it was also raised in the last class. That is res sub judice and res judicata. This I will discuss it tomorrow and then go to a new topic, please. Any more questions?
Sir, what is hypothecation under the TP Act, sir?
High Court?
Hypothecation.
Hypothecation. Hypothecation is HYPOTHECATION. That means where it is called pledge of immovable property is what is called hypothecation. I'll give you an example. Suppose, let us say you apply for loan facilities and your movable property is offered as security. Here the slotted angle rack which you have got, till such time it's not fastened to the earth, it is movable property. But it is when it is fastened with nuts and bolts, when it's fastened with nuts and bolts, it acquires the characteristics of immobile property. That's the reason why it is called hypothecation. Suppose you go for a vehicle loan, till such time you discharge the loan, the vehicle will be hypothecated to the bank or the authority which has granted you that loan facility. Why the word hypothecated is used is that means the bank will have the first charge over the property till such time the loan is completely paid or the EMIs are completely paid. Or suppose you buy a television set from Bajaj Electronics, etc., etc. They say you need not pay a single pipe, but you have to give 46 PDCs or what is called post-dated checks. Until such time you clear that loan, clear those installments, though you are the possessor of that particular property, it is not your own. That is the reason we use the word hypothecated. So long as the almaras or the what is called the started angle almaras which you have got, it is not fastened to the earth. It is movable property. But once it is fitted to the earth and fastened with nuts and bolts, it acquires the characteristics of immobile property. That's why the word hypothecation is used. And the property that has been offered as security is called the hypotheca. I mean, making it clear, Gauzia. Yes, next. Yes, next.
What do you mean by nuts and bolts, sir?
Nuts and bolts बोलो तो आपके नटा रहते ना, अपने सर पे भी रहता नट है. और bolts is where you lock it. That is called nuts and bolts. Am I right? Nuts and bolts is what when fixing to the ground, you want to the screws which has to be fitted to the almara to see that it is fastened to the earth. It is called nuts and bolts.
Sir, can you please differentiate between hypothecation and pledge, sir?
Madam, when I come to transfer of property act, I'll discuss it in detail, madam. As far as pledge is concerned, where movable property is offered as security for due repayment of a loan, it is called a pledge or it's called a pawn. As for then next one, what you asked?
Hypothecation, sir.
Hypothecation is where movable property acquires the characteristics of an immobile property. It is called pledge of immobile property. That is called hypothecation.
Yes, sir. Thank you, sir.
Any more questions? Any more questions? Any more questions? Can we conclude the class? Can we conclude the class?
Yes, sir.
Thank you. Bye-bye.
Thank you, sir.
Say tomorrow the remaining portions of CPC. The indicator is